Well, I think it's always good, of course, to have a lawyer just because that person can answer any questions that you have and deal with any issues that come up. I mean, the lawyer's not going to be able to do everything. That personal representative, executor of the estate is the one that has to go to the banks, that has to deal with the realtors, that has to, you have all that work you still have to do. So an attorney's not doing that for you, but is guiding you in answering your questions and letting you know the best way to handle issues as they come up and letting you know what needs to happen next and, kind of guiding you along.
Hey guys, welcome back to the Probate House Guy Podcast. I'm Brad Woodall, the Probate House Guy. We're going to continue our probate attorney episode, and today I have Eleanor Washburn from the Low Country of the U.S. in Charleston, South Carolina. Welcome to the show, Eleanor. How are you today?
Thank you. Thank you for having me.
So why don't you tell us a little bit about yourself?
I am a probate and estate planning attorney in Charleston, South Carolina, actually Mount Pleasant, right outside of Charleston. And my law firm is Charleston Estate Planning Law Firm. All I do is estate planning and probate and trust administration. And I've been doing that for close to 10 years now. And that's all I do. I've practiced law for many years, but eventually at some point decided to just concentrate in this one area. And I really enjoy it. And it's very rewarding.
Cool. And so what made you decide to go into the estate law from the other areas you focused in the past?
Well, I always dabbled in it a little bit, but it isn't the type of practice that you can dabble in, really. You really need to focus if you want to serve, a broad range of people in terms of estate planning. I think I did my first probate case when a family member passed away, a great uncle, and of course I'm the lawyer in the family, and so I have to do it, and I continue to do that. So I learned a lot sort of on my own, doing for family members, and I decided I really liked it, and I just started putting myself out there and to do it more for the public. Mm-hmm. And while it can sometimes be a contentious area, generally, you're helping people, and I've found that rewarding. I think also I'm a better estate planning lawyer because I do a lot on the other end as well. So I can kind of see how things can go wrong and how to, make a better plan so that things happen the way people want them to happen.
That's great. And, that kind of is one of the topics we usually cover, which is, what do you think the biggest mistakes that people make with their estates that cause more pain on the back end? Like, what would you say, maybe two or three, biggest mistakes they make?
Well, of course, the biggest mistake is not making a plan, but let's just assume we do make one. And that's right. The biggest mistake. People think, they're, don't want to think about death. They don't want to think about, don't want to make those decisions, think that they have another day to do it. And, and sometimes it can be too late. I think once you do make an estate plan, though, I think it's important to make sure that everything, some of your other assets that might pass by beneficiary designation or transfer on death or IRAs, those kind of things, investment accounts, make sure that those are lined up the way your estate plan is. So because those beneficiary designations are going to trump anything that you have in your estate plan. So we want to make sure that everything's lined up properly. So I think that's one of the big mistakes is people don't follow through with some of those things. I think that's, and not updating when they've changed their minds, trying to do an update by just writing it in the will, right. Which is ineffective.
Yeah.
So that's the other thing I see sometimes.
Yeah, we were just talking off camera. I'm about to have my baby daughter tomorrow, so I'm going to have to update my will and my estate plan because years ago when we did this, we weren't expecting to have any more kids, and now here we are. So I've got to update mine.
Right, exactly. Well, that's that's another one, right? Not updating when we have changes in our lives. I mean, hopefully the plan that you have anticipates that you might have additional children, and but it's always a good idea to go in and make sure of that. Make sure that you're not leaving anybody out, and that any changes in your life are reflected and it doesn't make you want to change anything in your plan.
Definitely, for sure. And for people that are coming to work with you, estates that are coming to work with you, what kind of tips do you have for them to help that process go smoother to work with you, to make that as most efficient as possible?
Well, I always ask people before they meet with me to be thinking about some things, and to be thinking about, one, what do they want to happen with their assets when they pass away? Who do they want to carry out their wishes? Who do they want to be that person to execute their estate plan? Who is the person who they might want to handle their financial affairs if they're not able to? Mm-hmm. Those are things that you just need to think about and plan for. And it's a good idea to have to know what that is, to make those decisions before, not necessarily before you meet with me, but be thinking about those. And I can always guide people to assist them in making that decision by explaining what the job entails, and they can select the person that they know would do the best job.
Sure. Yeah, because they might think, oh, yeah, Cousin Johnny's, he's a little bit of a crazy guy. He's probably not the best one to be.
Right. Or somebody might say, well, I don't, they want to go in birth order of their children or their adult children. And sometimes that's not necessarily the case. You want to select the person who's going to get the job done and is willing to do it as well.
Exactly. Yeah. And then, or if you have children and you've got to pass, someone has to be a guardian of your kids. Like who do you think would be the best parent to your kids, right?
Right. Exactly. That's another decision that young parents have to make too. Yeah.
Sure. Definitely. So in South Carolina, how long does the probate process typically take on average?
It takes about a year, and the probate process in South Carolina, it's fairly streamlined. It's very form driven. They have timelines for things, and generally when that 1 year mark, 1 year from date of death, the probate court wants to see everything done. So it's sort of, they'll start sending letters saying, how are you done yet? Have you done everything you're supposed to do? And so, so they try to move the cases along. And unless we've got some, sometimes there are outstanding issues and then we have to get a continuance, and we have to keep doing that until we get the issues resolved. But most of the time, everything's done. In fact, would be done before a year is up. Mm-hmm. But the year is basically when the creditor period expires. And so at that point in time, everything can be distributed. And if everything's been liquidated. And
mm-hmm. Now, does the creditor period, do you have to issue publication for a certain amount of time, or how does that work?
Right. So when you file your application and get appointed as the personal representative, you file an advertisement in a paper of local circulation, mm-hmm. Which is a notice to creditors, it lets them know that they have 8 months to file a claim with the probate court.
Okay.
So it would be 8 months, and that has to be published once a week for 3 weeks, but the 8 months runs from the first day of the first date of publication. Mm-hmm. And so we calculate that 8 months. That's for unknown creditors. There's also a statute that known creditors would have a year to file.
I see.
And so that's kind of extends it a little bit, but there's some ways you can shorten that by giving notice to the known creditors and things like that. So usually by 8 months, we can, we're satisfied that there are no more creditors.
Sounds like that's pretty similar to where I live in Georgia. I mean, we're right next to one another, right? We're pretty similar. We have to run for 5 weeks here in Georgia, publication once a week, every week for 5 weeks.
5 weeks, yeah.
Yeah. So it's pretty similar. And then I guess you mentioned, so I guess the statutorial drop dead date is 12 months of them to file a claim, but you said there's a way you could kind of push that a little earlier?
Yeah, you can shorten that by sending, and this is so that's a difference between unknown creditors and known creditors. You can send something to a known creditor and say, we're letting you know that this estate is open and you have this much time to file a claim. And it shortens, I think, it to 60 days from the notice.
Okay.
So we can do that sometimes when we want to go ahead and we don't want something coming at the last minute and want to go ahead and get that resolved.
Right. And if they don't submit in that time, that's it. They can't make a claim anymore.
Yes, it waits. Yeah.
That's Georgia's basically the same way too.
Yeah.
So. Okay. Cool. Yeah. That's a big thing, right? I've had so many cases where we had one last year, I think, and like last day of the publication, I forget what it was, Bank of America or something was like, oh, so-and-so owes $10,000. And it's like, that came out of left field,
I know. Well, sometimes we will do, or I will encourage my client to do get a credit report, so we can kind of see what's out there that we might not know about, and so that kind of puts us on, guard, I guess, so to speak, to kind of know who we might be hearing from.
Right.
So.
And all these states are different, right? And that's why we're doing these kind of 50 state episodes so people understand the nuances between state to state. So in South Carolina, can the heirs take any distribution from the estate before that 12 months is up, or do they have to wait, or they can do partial distributions, or?
They can do partial distributions, but it is up to the personal representative to make that decision, because ultimately they are the ones that are going to be responsible if there is a claim that comes in, that they don't know about and they've already distributed, or they've distributed some of it, but there's not enough left to deal with the creditor claim. So I would recommend partial distribution if there's a lot of cash sitting there and we know we're not going to need it. We've done our credit checks. We have not gotten any bills in the mail. We're pretty sure that there's nothing out there, but we just reserve some just in case. But, I think that it's reasonable to go ahead and make a partial distribution, especially when it's a significant amount of money sitting in an estate account.
Right. Yeah, I've heard of, I did another episode with an attorney, and he said he had a client that last minute Medicaid made a $700,000 claim against the estate.
Right. Well, see, in a case where I knew there was a Medicaid lien, I wouldn't do any kind of early distribution, because sometimes Medicaid files, sometimes they don't. So we just have to wait it out.
It's the government. They take their time to, I've had to help out doing some Medicaid stuff with a family member, and that is wow.
Yeah.
What a mess. What a mess, for sure.
Well, thank goodness we have it, though.
Yes. It was super beneficial in that circumstance, and very grateful to have it. It's just, as I think as a business owner, I look at the process to get it started, and I'm like, I'm a sharp guy, and it took me, 3 or 4 months to get this through. Like, I can only imagine someone who's less educated than me and less resources, like what they have to go through to get through this process. Just the money more than I do,
A lot of red tape.
Yeah, for sure. So that's crazy. So in terms of Medicaid in South Carolina, do you have Medicaid sponsored assisted living in South Carolina?
Yes, we do. It's means tested. You have to, your income has to be below a certain level. And of course your assets, you can't have, there's a certain limit to how many assets that cash basically that you can have.
Sure.
You can own a house, that does not exclude that's not counted in terms of whether or not you qualify for Medicaid.
Mm-hmm.
It won't make you sell your house during your lifetime. There's always that intent to return home, even though you're in a nursing home. So they don't make you sell your house.
Okay.
Which is sort of something that people assume. But
right, yeah.
But if you do qualify for Medicaid and you own a home, the glitch is what we just talked. Not the glitch, but the drawback is that Medicaid would have a lien.
Right.
On your assets after you pass away. So they would be entitled to be paid back. So your estate would sell your house at that point in time and if Medicaid files to be reimbursed, that has to be dealt with. So sometimes it's not as much as what your house is worth. I mean,
yes.
You own Medicaid some, but you don't owe them, your whole house. So
right.
So
do you guys have homestead exemptions in South Carolina like we do in Georgia, where it exempts a certain percentage? Okay.
No, we don't.
Okay.
Anything like that, like Florida. Yeah.
Yeah, I've done some Medicaid deals. We had to get an appraisal done. It had to be approved by Medicaid, to sell the asset or whatever, and they had to approve it. And, there was a portion that the family could get, but Medicaid got all the rest of it. In those cases.
Yeah, I think there may be some. No, I think there's no exemptions or anything. They won't make, if you have a surviving spouse, the surviving spouse wouldn't be required to sell the home if
okay,
they were still living in it.
I see.
Yeah, so.
But would those liens would still stay on the property until that spouse sells, or?
I think it depends. There's ways like you can have the house put into a trust so that, and as long as it's not we can do some trusts and some planning where we can preserve the home and keep it outside of your probate estate. So that and Medicaid would not have a lien. So, but that's something you have to do. There's a 5-year look back period, so you sort of need to plan ahead to do something like that. But that is a doable solution to the problem, especially when somebody, the major asset of their estate is their home, and they want their children to receive it. So there's some planning that we can do to make that happen.
Yeah, definitely. Yeah, it's funny because every state's kind of a little bit different. That's why we kind of bring that up. And that seems to be a common topic that we deal with sellers we deal with. A lot of times we're going to get someone who maybe they want to sell the house or they don't want to sell the house, but they're also, dad passed, but mom's still alive. So, and then mom passed, and there's a lot of dynamics in that, and sometimes there's multiple houses and that sort of thing. So it gets a little complicated.
Right.
In South Carolina, how much does probate typically cost for like your average estate? Like how much does that usually run?
We have, of course, attorney's fees if you need an attorney, and you generally do if there's real estate involved in any significant assets. So, and of course, attorneys charge different things. Some charge a percentage of the probate estate. Some charge, just hourly. So that would depend. But I would say minimum probably around in this area, maybe attorney's fees around $5,000, $5,000 to $10,000. And then we've got the other expense is the probate court fees.
Sure.
So they charge fees based on the value of the estate. That's kind of how they run their office, with those funds. And so that could be, as little as $95 or as much as about, I don't know, maybe $2,000 per million.
Okay. 2,000 per million. Okay.
Yeah. So, and then of course there's, so that's about the, average, probably, cost for probate. And of course there's always a way to avoid probate by creating a trust, but well, we don't need to go into that right now, but
that, was it 70% of people die intestate, right?
Yeah.
Something like that. So, I mean, that, it's 70% of people that don't have anything in place. And then, the percentage of people that I can tell you, I've done hundreds of real estate deals and bought houses, and I've had two trusts. That's it. Two. And I can count them. Isn't that wild that all these houses and only two families had done a trust?
Yeah, well, a lot of people think that they have to be rich to do a trust, and that their property has to be, worth a lot of money, to do a trust. And in some ways that might be true because a trust can be more expensive to do on the front end, but it's always less expensive on the back end when it comes to avoiding probate court fees and that sort of thing. But really, you still have to administer the estate, whether you have a trust or it's going through probate. It's still the same things have to be done. Property has to be sold.
Right.
Heirs have to be notified. creditors have to be paid. So it's all the same. It's just you're not really having to go through the probate court and going, on their timeline.
Right. Which can slow things down, know, for sure. Definitely. Right. I mean, you're going to pay for it. Whoop, I hit my mic. You're going to pay for it one way or another, right? So do you want to pay it early or do you want to pay it later? It's for you to decide, right?
And it's also real important to have a trust if you have real estate in more than one state.
Yeah.
Because you're definitely going to save money in that case because a probate case has to be opened in every state in which you own property. So you end up, doubling and tripling that cost.
Yeah.
Whereas if everything's all in one trust, we don't have to deal with probate in all the different states.
Because the trust owns the real estate, not the person. Yeah.
Right. And we have,
So do you guys have ways and maybe you do this, maybe you don't, some attorneys do this in terms of helping alleviate the costs? I think a lot of people we run into, they can't afford or they think they can't afford probate, so they don't probate, which then creates a whole slew of issues down the road. Are there ways to kind of help alleviate that cost, payment plans, or, some of my attorneys locally here in Georgia, I paid their kind of retainer and then they get paid on the back end when the property sells.
Yes, that's sometimes some, of course that's up to the attorney but I have done that, especially when there's no cash in the estate.
Right.
But we know there will be when we sell the property. I will, just agree to wait until there is some cash before I get paid.
Yeah.
And then also, there are always usually resources in your community, pro bono programs. If you really feel like you cannot afford to, and you don't feel like you can do it yourself, because sometimes if it's simple, a lay person can do it. But then there are pro bono programs or low bono programs that would assist somebody with that. I do that work sometimes. I just have them qualified through the pro bono program, and then I'll agree to take the case. But
is that a state program or like a local?
We're lucky because we have a separate program in Charleston.
Okay.
But we also have a state program, and we have also just a Charleston attorney pro bono program.
Okay. It's like a sort of an attorney group kind of thing, and you guys.
Right. Well, yeah, it's a nonprofit that and that attorneys volunteer under. And we also have a legal access program so that they will do things like on a sliding scale. So often, your legal community will have programs like that, and you can find out about that through usually the State Bar Association.
That's super neat. Yeah, just hearing about, like, I was doing an episode with an attorney from New York, and New York has a whole thing set up, a whole fund, and they have all this money set aside and through the state. Obviously, you're paying that in your taxes, but that's kind of neat, for people who can't. Because I've dealt with sometimes multiple generations of families who didn't probate because they couldn't afford it, and then now 3 generations later they want to sell great grandma's house, and we're like, guys, we gotta probate 3 different estates now, and that's going to be like $10,000-$15,000.
Yeah, and it happens, and but a lot of times it's just they don't know they need to do it.
Sure.
Or don't have the money to do it. Most often I think it's because they don't know they need to do it. And
they just, I had a will, I'm the executor, I can sell it.
Yeah. Or this is my, our family property. So it's always going to be our family property. And they don't really understand that we've got to do deeds and, keep the chain of title proper.
Yeah. Especially at Charleston, because it's such a kind of an old city, right? It's been around for a long time. You deal with some very old estates there.
And we have a whole program here for that to assist people. It's a Center for Heirs property and to assist people in straightening out their. That's another nonprofit program just for families who want to try to keep their land in the family but want to get the title straightened out. This program will help them do that.
Okay, that's really cool. Okay, cool. So you were mentioning that someone can do probate themselves if they want to, if it's easy. They're allowed to do it themselves in South Carolina, right?
Right. Like I said, it's very form driven. So, you fill in the blanks. The clerk will tell you what form you need to file next. Sometime, but they only help you so much. They can't give you any legal advice.
Right.
So if there's any kind of, issue that comes up, hopefully there isn't. But if there is, you may need to get an attorney, but you can try to do it yourself. Ultimately, if there's real estate involved, attorneys will have to get involved. In terms of, either transferring the property by a deed of distribution. That's something that an attorney, should prepare. But sometimes I can just do just that for somebody. If they handle all the probate and I'll do the deed once they've done everything. So it just depends on, how complicated it is and how much time that person has and, their confidence level in handling that kind of thing.
Yeah, we always people that's a topic or a question that we get sometimes. And it's like, well, it depends on your comfort level. Are you kind of a sharp person? Like if you're not and you don't like all this paperwork and all this stuff, maybe that's probably not the thing for you, or if you get frustrated with dealing with the government and how slow their processes are,
Right. Well, I think it's always good, of course, to have a lawyer just because that person can answer any questions that you have and deal with any issues that come up. I mean, the lawyer's not going to be able to do everything. That personal representative, executor of the estate is the one that has to go to the banks, that has to deal with the realtors, that has to, you have all that work you still have to do. So an attorney's not doing that for you, but is guiding you in answering your questions and letting you know the best way to handle issues as they come up and letting you know what needs to happen next and, kind of guiding you along.
For sure. We always recommend to people that they work with an attorney. Because you don't know what you don't know and you can come up against things and then you're kind of stuck and the court doesn't really care that you don't know. They want it done a certain way. So
Right.
Yeah, definitely. Yeah. So in terms of families wanting to keep properties in the estate and then families selling an estate in South Carolina, can you sell real estate outside of probate? Like, is there, like in Georgia, if a certain amount of years have passed, there's some states have affidavits of heirship or that sort of thing after a certain amount of time. Do you guys have that in South Carolina? So like an affidavit of heirship or something. So like in Texas, like there's no waiting period in Texas. Like if all the heirs sign off and agree, sign an affidavit of heirship, you can transfer title to the real estate and not even have to probate anything. You just do these and you submit it to the probate court and they approve it. And that's that. Like you don't have to go through that whole rigmarole.
Yeah, well, I think there are three issues. One, if you have a property in the estate, it does have to go through probate because somebody has to have authority to sign that deed.
Right.
So, and whether that's a deed to a third person or whether that's the deed to the beneficiaries, that would be a deed of distribution, essentially. So, there different situations would give rise to these different scenarios, but a personal representative could sell the property while probate was open.
Okay.
And then put the cash in the estate account, and that would ultimately be distributed to the beneficiaries. Okay. That's often done when there's a mortgage outstanding or where there's a lot of debt that needs to be paid. And so we need to sell the house to cover those debts. Or the personal representative can just sign a deed of distribution to the beneficiaries. Mm-hmm. So whether it's 3 people, 2 people, 1 person, whatever, they can just go ahead and sign that deed over to that beneficiary, and then that beneficiary can sell the property personally.
I see. Okay.
Or those beneficiaries can sell it personally.
I see.
The other thing that could happen is that probate is never opened, like the situation we talked about before.
Sure.
As long as it has not been 10 years from the date of death, probate can be filed. And especially, if there's a will, the will can be probated and this property distributed to the people who are supposed to get it according to the will.
Right.
If it has been over 10 years, even if there is a will, it doesn't have any effect anymore. So that's one thing that might be a little different about South Carolina. So then the estate has to be probated as if there was no will.
So
that requires, so it's basically a formal petition to the probate court to determine the heirs. And so that could have been, 11 years ago. It might have been 25 years ago. So it doesn't really, you don't really know until you get in, it can be a lot of heirs. It can just be a few, but we have to bring an action to determine the heirs. And so, I always, 10 years is that. Yeah. So after that, it's a long process to get an order from the court that says, here's who owns this property now.
Yeah. And I had one years ago, we went down this path. It was one of those multi-generational things. There was 31 or 32 heirs involved in this estate. It was crazy. I've never seen so many people. So that's an interesting. That's the first time I've heard of that. The whole 10 years thing. So you're basically essentially just almost filing like an administration and following the rules of intestate succession at that point, right?
Right. So sometimes there's no will anyway, and but even if it's within that 10-year period, you don't have to do the determination of heirs. So you can just determine, but after that, you have to get a court order as to who the heirs are.
So if there's a will and the will says Susie gets everything and Johnny gets nothing, right after 10 years, Susie and Johnny are both entitled to,
Exactly. Right.
Exactly.
So
Gotcha. Okay.
But like I said, when people come into me, usually they knew that was never done or they didn't know. It might have been grandmother's property and, their parents they're both gone, grandparents and parents, and all of a sudden they realize that it's still in grandma's name who died 20 years ago. So, and then we have to straighten all that out. Sometimes people come into me and their spouse passed away 9 years ago and they didn't know that they didn't own the house. And we get on the stick real quick.
Yeah, right. Yeah, time is a ticking there.
Yeah. So anyway, that's the magic.
In South Carolina, so you mentioned, they can kind of sell, they can get the authorization to sell and kind of go ahead and do that kind of halfway, let's call it halfway through the probate process or whatever. How long does that typically take? Let's say a family needs to pay some debts, time's ticking, maybe the house is in foreclosure, something like that. How quickly can a personal representative of the estate get the authorization to sell the real estate in the estate?
Well, it depends. If there's a will and the will says that the personal representative has the authority to sell the real estate, it has to say that. Okay. If it does say that, the personal representative can sell it immediately. Okay. And so they just have the authority by the will, according to the terms of the will, and according to they've been appointed by the court as the personal representative. So they're immediately able to sell the property. If there is no will or the will does not specify that the personal representative has the power to sell real estate, a formal petition has to be filed requesting an order from the court allowing the personal representative to sell the property. And usually we have to get an order to determine about the range at which it would a court would approve a sale. Mm-hmm. That can be done fairly quickly, especially if everybody is in agreement. I can usually get all the paperwork together and file it. And again, as long as everybody agrees, all the beneficiaries agree to the price, all of and the lender, if there's a mortgage. Mm-hmm. So if everybody agrees, I can usually get that order fairly quickly.
Okay.
But again, it's expensive, so it's better to have a will that says your personal representative has authority to sell.
Sure. And if you've got a will and you're petitioning to probate the will, how quickly does that typically take for the court to basically say, hey, executor, you're good. We've reviewed the will. You're good. Go about your duties, right? You have the power. How long?
Of course that varies by county, but and I service about 3 counties around here, but usually in some of them we file electronically, some of them it's still in the mail, so all that kind of makes things last a little longer, but it can be anywhere from a week to 2 weeks. It doesn't usually take very.
That's not long at all.
Yeah.
It's pretty quick. Okay.
Yeah. And again, that's as long as, it's the personal representative that's named in the will, or everybody agrees on the personal representative if there's no will. So as long as everybody, everything goes smoothly, that's usually the case.
So, and on that note, you mentioned about assessing value and stuff. Are estate appraisals required in South Carolina, or are they just sort of a recommended thing?
They are recommended. They're not required. We do have to file an inventory and appraisal. And the inventory, some people will use tax value, but of course that usually is less than real market value.
Right.
Some people will be planning to sell it, and they've discussed it with a realtor, and the realtor will tell them what they think they'll get for it, and we might use that on the inventory. I only recommend an appraisal if the family is intending to keep the property, and that would just be because they want to establish their cost basis in the property. When you inherit property, your cost basis is the value on the date of death. So you want to determine that, and you want to be able to prove that to the IRS if you ever got audited. So I always recommend a formal appraisal if you're going to keep the property.
I see.
Planning to sell it, an appraisal really isn't necessary because it's going to sell within the next year or so, and that's a good indication of what the market value was, right?
Right.
So if we have to do the inventory before that time, we will, use our best guess. But if it sells for a lot more or a lot less, I'll amend the inventory for what it actually sold for.
I see. Okay. Interesting. Well, that's cool. So in South Carolina, if you mentioned there were some debts involved on estates and stuff. So if an estate is going to be insolvent, and I'm sure you've run into this a time or two, are there situations where it might be worth the family to probate the estate versus not probating the estate at all and just kind of letting it go? Like what, are there certain instances where you think that would be better?
Well, there are certain instances where there's no need to probate the estate because there aren't any assets. And so that would be, unfortunately, if there are assets, but we know they're debts that far exceed the assets, you still have to probate because otherwise those assets are never going to get to the people that are supposed to receive them. And we can't leave property in a decedent's name.
Right.
Sometimes you can wait so that you can wait till after a year. Like I said, you have 10 years, so you can wait till after a year before you file, and then there won't be any creditor claims. So the theory behind that is a creditor can file probate. So if a creditor knows that they're owed money, that somebody passed away, that they have an estate, they have the right to open probate. So it's not really cheating the creditor because they have rights. But sometimes we'll just wait till the year is up and see if anybody files anything. And if they don't, then we can go ahead and probate.
Interesting. Yeah, Georgia's similar. The creditors can open a probate here in Georgia as well. And because some people have been surprised. They're like, who opened a probate? It's like, Johnny from Bank of America opened your probate.
Right. And so they can push you to go ahead and administer the estate during, that creditor period. So.
Yeah. And so that's very interesting. And so we covered that. And you mentioned the timeline. I'm just running through my questions here, more common questions. Are there anything, or what are the common things that you see in South Carolina that would invalidate a will?
The requirements for a will in South Carolina are that it be signed by the testator or the person who's creating the will, and that it be witnessed by two people. And they have to be two uninterested people. In other words, people who would not stand to inherit either in the will or if they were heirs. So they have to be two independent witnesses. It's not required that the will be notarized or the signature of the testator be notarized, but it's recommended because it makes the will self-proving. So if if the will has not been notarized, then we generally have to get one of the witnesses to testify that, yes, they witnessed the will. So sometimes that's difficult because we don't know where that witness is if it's an old will.
Yes.
So a notary is always the best practice. So that's the only thing that really invalidates a will, is that that it has not been witnessed, or it hasn't been signed at all.
Interesting. Yeah, we had a unique one a few years ago where the will was notarized and it had witnesses, and the notary forgot to put her stamp on the will. She signed it, right? Notary and whatever, but she didn't put her stamp on the will. So the title company and the attorney said, well, it wasn't notarized. She didn't, it's not fully done. So we had to track down the two witnesses. And fortunately, they were still alive, and they had to provide affidavits to say, yeah, I was there. I witnessed it. I signed it. Fortunately, we got a hold of them, and we were still able to probate the will, but it was like, oh, no.
Yeah. Well, so I think that might be a state-specific thing, because I think as long as, and then, of course, what a title company wants is what a title company wants. So, but I would say generally, at least in South Carolina, a notary does not have to necessarily stamp a document if it's a document that's going to be used within the state. But you never know where somebody is going to be when they pass away. So it's always a better practice to have the notary stamp it so that, it doesn't matter if it's probated in another state.
I see. And how does South Carolina handle like missing heirs? Like if you've got to kind of, you mentioned earlier notifying the heirs, and let's say you've got a will that says Susie doesn't get anything. How do you guys handle that if you can't find somebody? Does money go into a trust account or like set aside, or how's that handled in South Carolina?
Yeah, it doesn't happen often, but it can. And so essentially what, the personal representative has a responsibility to locate all of the heirs. If we can advertise for unknown heirs, sometimes if it's, one of those cases where we're going back several years, sometime, and then appoint a guardian ad litem to represent them, those unknown heirs, so to speak. So that's one issue, and one way we get around that. But then there's also the issue, which might have been more your question: what happens when we know about an heir, but we just don't know where they are?
Yes.
Oh, yeah. So that's a whole nother thing. Of course, we there's lots of ways that you can try to find, and you just use your your best efforts to do that. Sometimes Social Security can help. They won't necessarily give you that number, but they will notify this person as a courtesy to notify you. That's one way. The IRS sort of has a similar program that they'll do. And there's people that do skip tracing and all that. But ultimately, if you can't find anybody, what I would normally do is I would just request the court to instruct me what to do with that money. So they are, and it could be something that gets turned over to the state. Or it could be something that the court holds. I think it just depends on the court, the county, and I would just seek the guidance of the judge to find out what to do.
You're not stuck. The court will tell you what they want you to do. So.
Right. I certainly don't want to hold it in my escrow account. The person that want to hold it, in their, they're not going to be personal representative forever, so they want to get discharged. So we'll just get instructions from the court as to what they want us to do.
Awesome. We've kind of run out of time here for today. I know you've got a hard stop here in a few minutes, but if somebody's in the real estate space and they were interested in working with you, what advice would you have for them if they wanted to, work with you on a regular basis? Like you mentioned, you have some agents you work with and stuff like that. Do you have some tips for them on, the best way?
I think, I have had realtors that come to me that, are interested in assisting with probate cases, and it is a nice niche for them to be in because there is a lot of different scenarios that happen, a lot of different dynamics, a lot of information that they should know or they quickly learn when they're dealing in this area, and so down to even I think one of the services I think that are very helpful for a realtor to be able to give is to help the family get the house ready to sell. Usually these realtors that are very concentrated in this area. They have a, lists of people who will clean out the house, lists of people who will do auctions, for personal property, lists of people who will clean the house, those kind of things, because sometimes people are from out of state. They don't know anybody here. They don't know, so being that kind of a resource, I think, is really very, very helpful. Rather than just wanting to go in and list a house. And, but I think you can, as a realtor, provide a more, broad service, by helping them with those things.
For sure. 100%. Yeah, I totally agree with that. So if someone's interested, they're in the Charleston market or they're dealing with an estate in the Charleston market, and you mentioned you service 3 counties around Charleston?
Right. Dorchester, Berkeley, and Charleston County. Generally, I mean, I can really do it.
You can do anywhere in South Carolina,
county, but that's where I am located. Yeah.
And if they're interested in working with you, what's the best way to get a hold of you and your firm? How would they reach?
My website, which is charlestonestatePlanning.com.
Okay.
And my phone number, 843-972-3391. And those are the best ways to get in touch with us.
Awesome. Great. Well, hey, Eleanor, I really appreciate you coming on to the show today. You're a wealth of information for South Carolina. You're just not too far away from me there, just a few hours away. I actually have a buddy in South Carolina I should connect you with. He's the Charleston House Guy. That's his brand. That's where I got my Probate House Guy thing from him. I asked his permission if I could use that, but he's in your market there. Thanks for coming on the show today. Really appreciate your time. We'll put your information in the show notes if anybody wants to get a hold of you. They can reach out to you. And again, thank you so much.
You're welcome. Thank you for having me.
All right. Well, have a great day. Have a good weekend. Thanks for coming.
You too. You too. Bye-bye.
Talk to you later. Bye-bye.